I will now call 126-270 in the matter of Kevin T. Cure.
May it please the court, I'm Kathleen Seltzer-Lippert on behalf of the Disciplinary Administrator's Office.
For Kevin Cure, respondent in these proceedings.
This is an original action in attorney discipline. Cure was originally licensed to practice law in Kansas in 1991. This case is before the court after an evidentiary hearing that included a joint stipulation, both facts and rule violations. No exceptions were filed by the parties. The primary issue before the court today is the appropriate discipline. At the final hearing report, the hearing panel recommended a 1-year suspension plus a reinstatement hearing. My recommendation would be to ask this court to adopt the hearing panel or the final hearing report with respect to the disposition or sanction. It's my understanding that also Mr. Cure comes today with that same recommendation.
Clarify for me again, Ms. Seltzer-Lippert, the hearing panel recommended 1 year with a reinstatement.
Yes,
At the hearing, you recommended a 2-year, correct, with a reinstatement.
yes,
And now you're modifying your recommendation?
yes, yes, Justice.
Thank you.
And the reason for that, one of the reasons, is actually from Mr. Cure's prior case, 2019. This court, in the discussion, referenced or pointed to Henry Holmes, and said that giving deference to the hearing panel that heard the evidence when the severity of the sanction depends on the facts and circumstances, that this court did give deference to the hearing panel. And I think it's appropriate in this case. Based on the stipulation and to both the evidence, the facts, and the rule violations, those issues are not really are not contested. There's no contesting of that. I think that the key issue is what is the appropriate sanction. There was, as part of the evidence, the evaluation that was thorough, comprehensive, and made a number of recommendations. Mr. Cure's witness and treatment provider described that evaluation as accurate, excellent, thought that the evaluator hit all of the points that needed to be.
Which evaluation is this?
There was
What year?
it was made in preparation for the final or the hearing. So it was Exhibit 18. I think it was completed January of 2023. I don't remember the exact date of, but it's Exhibit 18.
Would you say that that in his prior, as they were getting ready for the hearing panel in October of 2020, that the treatment providers submitted a glowing, also submitted a glowing recommendation and how he was doing in treatment also, correct?
So that was part of the reinstatement hearing.
Correct.
Yes, at that point in time, and Mr. Cure presented at his reinstatement hearing a number of exhibits, provided the testimony of KLAP, of his daughter, of individuals that he had been working with. And at that point in time, he was doing well in his recovery and his treatment. And in fact, the Supreme Court, your order of reinstatement provided reinstatement with the requirement that he sign a KLAP, which did require abstinence and some.
Did he comply with that?
And shortly after his reinstatement, started his non-compliance with that. It's not exactly clear. At different points in times, he indicated perhaps May is when he resumed consuming. There were a couple of different times where he indicated different points when exactly the non-compliance started with the previous, or with the order of reinstatement.
So how much weight should we give this 2023 treatment provider's submission, given the history here?
So the treatment provider sets forth a number of recommendations. First and foremost, or the first treatment recommendation, or the first recommendation out of that evaluation is abstinence. The hearing, or the evidence of the record is at the time of the hearing, he had not reached that point yet, which the underlying suspension is justified based on the ABA rules or guidelines. I apologize, the ABA guidelines, but it's also justified here to provide him an opportunity to really get those measures in place so that
Are they in place now?
we don't have evidence of that. Mr. Kier asked for probation initially at the hearing panel, or before the hearing panel. The hearing panel in the final hearing report determined that probation was not appropriate for a number of reasons. First and foremost, it was not thorough, it was not complete, it was not
You
comprehensive.
working with KLAP right now?
I would let him speak to that. It's not my understanding that he is, or the nature and extent of how he's working with that.
Okay, and I'd like to go over, because you had mentioned that what we're looking at here is discipline. I'd like to go over the panel's aggravating and mitigating. On aggravating, they talk about prior discipline and dishonest and selfish motive, but they said that this is not the same pattern of misconduct, which, would you agree that the misconduct, the underlying behavior of the misconduct here is all based on his substance use disorder?
Yes.
So would you say
Absolutely.
that it actually is a pattern of misconduct?
And that is what I argued at the to the hearing panel. The specific rule violations are not the same, but the root cause is the same. The root
You would
cause-
agree we should add that back in as an aggravating factor?
So I did not file any exceptions and did not make any exceptions. That was certainly my argument, that the root cause in both the first case and this case, that the rule violations are not the same, but the root cause is.
Also, they found that substantial experience, which you had said was an aggravating factor, they said that that was not an aggravating factor because he was suspended for a period of time and he had not had felony appointments for 15 years. What is your opinion about that? I mean, he's been practicing for over 30 years.
My opinion is that, yes, his length of time in practice, it's overall, the experience in the practice of law is significant. The hearing panel appeared to sort of parse experience in the practice of law into whether you've practiced criminal law for an extended period of time versus other types of law. I think experience in the practice of law doesn't parse it into individual practice levels.
And going to that, the panel found it mitigating that he had a case overload and too many administrative functions, and that was a mitigating factor, but he had been in practice for 30 years and running his own law office for 30 years. How is that mitigating?
That was not a mitigating factor that I proposed or supported or argued for in front of the hearing panel. I believe that was their conclusion.
Do you know why the panel found as a mitigating circumstance that he's still drinking?
No.
And then related health issues to do with his drinking, they said was a mitigating factor. And then they did say alcoholism is not a mitigating factor because he does not have a sustained period of time, and and recurrence is likely. So based on that, would you want to change your recommendation on discipline? Given the fact that he's, you have no knowledge of whether he's even complying with KLAP now, which, I guess you have no knowledge of whether he's being alcohol even now. And then the fact that we talked about the aggravating and mitigating factors, the fact that he did not comply with KLAP, would that change your recommendation?
There are, the recommendation in this case is very difficult. And there's case law and there is support for much harsher sanctions. And I think some of that can be found, for instance, in the Johnson case, which is 227 Kansas 478 from 1980. Procedurally, that was a little bit different because the Supreme Court had issued an order of
Well, all of these cases are going to be different, and I think there's a lot of case law out there that talks about that we are supposed to look at the specific facts of every case. And we're not going to find a case like this where when you look at the history of the prior discipline, we're not going to find a case that has this. I guess, in the office of the disciplinary administrator is supposed to protect, the citizens of Kansas when they're hiring a lawyer. Would you hire him for a lawyer right now?
no.
And what would a year suspension make a difference?
I think there are two components, the suspension, the period of suspension, but I think more important than the actual time is the requirement of a reinstatement hearing.
But we've already gone through that. And what has that shown us? That literally within a month of his reinstatement hearing, we have this, we have a complaint and we have drinking.
That is true. I don't know if he would be able to walk through and accomplish all of the recommendations set forth in the evaluation from January of 23. There were fairly significant recommendations. It's always speculation what evidence would be presented at a reinstatement hearing, but I would expect to see, I don't know that he could accomplish those tasks in 1 year. But that would be the earliest that he could come back and ask for and demonstrate all of those
And it was
things.
18 months before, right? So you're asking for a lesser amount of time.
Chief, Chief, may I ask a question? One of the things we have to consider is appropriate sanction, of course, and addressing things appropriately. We've talked a lot about problem with alcohol and how he's dealt with that. One of the things, though, that struck me as being particularly concerning here was how the plea agreement was handled. And I want to make sure that I'm clear on what happened. Based on what I read in the hearing report, the final hearing report, Mr. Cure had a plea agreement that had been okayed by the prosecutor and probably was all right with his client as well. And he held that agreement and did not give it to his client because he wanted to be paid. And that concerns me very much. Is that correct? Am I correct that he held it until he could be paid and told his client, I've got this, pay me, and then you can have it?
Yes, I think you are correct. I would like to sort of clarify a couple of nuances of the facts, because he didn't actually say, I've got this, but I won't give it to you until you pay me. But yes, he had a plea offer from the prosecutor in July. His file notes show from July 24th. He had a conversation with a client about the plea offer, and his file notes said that the client believes that this plea will greatly assist him in the custody case, so his client wants to accept the plea. There is a text message from August where the client is asking about signing the plea before he goes into treatment. And so we have this, the client wants this plea. And with respect to the payment, and I think this is why the hearing panel found that it was a selfish motive, an aggravating factor, because he called and left or left a voicemail message, which there's a recording and it's an exhibit for you to hear, where he says that he's making this change. He wants his client to invest in some election campaign signs, yard signs for a local election. So, and that the text messages that follow that and the conversations that follow that the client wants this plea. In fact, that's why the client went to both the sheriff and the prosecutor. The prosecutor, of course, couldn't talk to the client because he's represented. But the client just wants his plea. So yes, and when Mr. Keir was interviewed by the investigator working on this case, the investigator asked him if he believed he could refuse to let his client have a copy of the plea because of the non-payment, and the respondent did not directly answer that question to the investigator, but the investigator got the impression that he thought it was not unreasonable. The respondent said that he wasn't pulling the plea deal, he just wanted to get paid. So those were the words that Mr. Keir, investigator, which is the foundation and the support for the aggravating factor of selfishness, which I think is demonstrated here.
But not extortion.
I have not looked at it from the perspective of extortion. I looked at it from the perspective of a selfish motive, not doing what his client wanted to do, a violation of 1.2. The client directed him, let's get this done, or I want this plea. But yes, it is significant.
Questions?
I see my time is up, so I will cede.
All right, thank you. Mr. Keir?
First of all, I wanted to thank this court for granting the 2 continuances that were asked for the health reasons. And I didn't anticipate those things, but I'm glad they're done, or mostly done. Appreciate that. Only other thing I'd mention in that regard, I'm still a little dizzy from it, so pardon me if I am. I read through the final hearing report, and it was accurate, and I file any exceptions. Quick to realize that was my conduct. I guess I got caught in the middle of taking on too many cases. Couldn't find good staffing. It's early in the COVID area. And I was doing a one-man show instead of having people to assist. All these felony appointments, and I got some of the worst ones because I'd had experience, they had my cell phone number and they called all the time. Some of them would call 25 times a day. I guess at some point, trying to roll from one court to another, be prepared for the cases. And I did achieve good outcomes in those cases. Only 2 out of those clients went to prison. I mean, so So I worked hard. I read the law, but it was stressing the heck out of me. Live alone. There was no support at home. I was debating, do I take care of myself or do I go to these support sources, AA, or do I try to keep up with these clients and maybe get to some bids billing at some point? I still have a ton of cases that need billed. And I planned on doing that this fall, but the health reasons struck, which were quite debilitating. I wanted to mention this court, the intoxilizer is still in place, so I can't drive anywhere. It's there for another 4+ years. So Missouri gave you a 10-year one based upon the 4th DUI.
How does that work? Does that report back to anybody? Do you have
Yes.
to get it serviced once a year, or how does that work?
That's actually every month you go in.
Every month you go
It
in?
will not start the car if you blow anything into it otherwise. So, and then once a month you go into a local station and they send a,
And have you kept up with that?
yeah. I have, except for this month. There's a couple weeks where the battery went down. I fell on my head last week.
Last week you fell on your head?
Going down the stairs, taking down Christmas decorations and just fell on my back. So, and it swelled a little bit, but I waited for the end of the week and it had not did what it did last time to me. So
Okay, so you missed the December?
no, just this month.
Oh, January?
Yeah, so I'm only, I think 10 days late right now. So as soon as I get back, I'll get into the, I had a hard time finding somebody to charge the battery, but I also need to prepare for this. And there's a lot of things to balance. And I'm trying to wind down my clients in anticipation of discipline. So it's always, that will be the first time, so it shouldn't have any effect.
Mr. Kira, did you keep the plea agreement until you could get paid purposely?
I don't know if it's that, or if I was just so busy, I didn't think it was time to get him in. Now, I
Did you
did tell him
intend-
once, yeah.
Did
So
you
you're
intend-
right. So I did do that once, yes.
And to use it as leverage to be paid?
Yes.
What are you asking for?
What am I asking for?
Yeah, from us.
Well, I did get out there and conscientiously take care of my clients pretty dang well.
And here's what I'm having trouble with, Mr. Cure. I've done this a long time, and you're one of the few people that has come before us who has been prior suspended and didn't comply with conditions to get back in from that suspension. You had a monitoring program that you haven't complied with. You haven't even provided us or the disciplinary administrator with any updates on where you're at now. I'm having trouble in getting in the broad view, not understanding why you shouldn't be indefinitely suspended. I mean, you're here having done nothing, as far as I can tell. And in asking us to say why we should consider your published censure or whatever you're considering, you haven't done anything.
I know I haven't performed up to the standards I should have. I have
And then
done,
engaged in conduct that is reprehensible as I read what occurred with your client. And as Justice Wilson pointed out, I don't know if it's extortion, but you withheld the plea agreement. And this is after all of the discipline had occurred from your initial suspension. Explain to me why we should consider anything short of what I just suggested.
well, here's what I'd say is I have conscientiously worked for my clients. I did get good results for them. even in this case, he got a good plea agreement. But I have served a small community pretty well. I've had a long life of governmental service. I even, in my downtime, rewrote the Judicial Tax Lien Foreclosure Act, first major revision it would have been since 1941, and it got submitted to the legislature. So I do work hard. I do have good abilities. And I let my personal circumstances get in the way again. And addiction is a tricky thing, but I don't deserve anything from this court. But I can say if I get another opportunity, and I'm not asking for a personal censure, I'll ask the court to follow the panel's recommendations if it would. And I love the law. I want to finish practicing. I was stupid for being here again. And I don't think I'd make such a failure should I get one more opportunity. But perhaps in a year and a half or two, I can have everything and show a long track record. And the circumstances of my life may not be the same. And I will come out better able to manage it. I won't take on so many cases.
Do you think that's the issue, taking on so many cases, or do you think that your substance use disorder is the reason?
I think it triggered me back into doing that, using again, having too much. It was all day long. In the evenings, the clients were calling relentlessly. They had nothing else to do in the jail sometime, and in Crawford County, they can call all they want. So I think the two are tied together.
What are you doing now to address your substance use disorder?
I'm seeing a counselor named Dr. Londe.
Are you going to AA meetings?
No, I am.
Even though you were the treasurer? Weren't you the treasurer of your
Yes.
group?
I was.
Don't go to that meeting anymore?
Well, I got in this trap of try to keep up with the clients and their work and try not to get another bar complaint from them and get good results.
You still drink alcohol?
Yes, back in early December, yes. It's hard to abstain. I'm working on it.
So I understand that it is, it's definitely a disorder, and it is, I understand.
Well, this
And it
time,
takes, it has to be. I'm not putting any blame. It's just, in this kind of proceeding, what we're tasked with is protecting the public. And so as difficult a task as it may be for you to overcome what is a medical condition, a recognized medical condition, like diabetes. Our task is protecting the public. And so I'm not putting any blame on you or accusations or anything.
it's hard to have statistics, but the public was protected in this instance for the most part, in that in almost every case I had, a successful outcome was achieved. And I've always done that throughout my career. And a well-respected lawyer before I developed this drinking problem. But I'm still quite capable of doing my job. Now then, I don't want to keep drinking because it's going to kill me at some point.
Is it your position that you can still function while you're drinking? You can be a good lawyer while you're drinking?
No, I work during the day, get work done
And then drink at night?
sometimes, yes.
Yeah. And so you've got it under control?
Yes, from that standpoint, I feel that way, yes. Any other questions? Thank you for your time.
I don't have anything particular to add, but am available for questions.
Thank you. Thank you to both of you. We will take this matter under advisement.